Good morning, everyone. I'm Matthew Roberts, and this is Jones DeBose. We're both with Nexsen Pruet, and we're happy to be here and happy that you're here to start off our first of several webinars on life sciences issues. And today we're going to go over at a high level corporate issues that are affecting life sciences companies. And what we're trying to do in this short amount of time is cover a lot of ground and to address issues that are important for startup entities and issues that are important for larger, more established entities. And what we hope to do is to give you at least something to think about, making sure you're thinking about these issues, because we see these issues as having an impact on our life sciences company. So this will be about 30 to 40-minute webinar, and then we'll have opportunities to ask questions afterwards. You are encouraged to use the chat feature, the chat box feature for your questions, and direct all questions to all panelists. And then at the end of the webinar, we'll go over read the questions and give you answers. If you're any other questions, just about audio, please send. If you can't see or hear, please let us know also through the chat feature. So we're going to go ahead and get started, and I'm going to introduce Jones DeBose, who is one of our corporate lawyers who works a lot in the healthcare industry, but he does a lot of M&A work and forms entities and advises them during the course of their existence, and also provides advice on the purchase and sale of entities. So Jones, good morning.
Yeah. Good morning. Thank you, Matthew. And I'm going to start off with at the very start. We're really going to kind of go through the life cycle of a company. So that would be from formation through growth, through its governance, and through the sale of the company. And what we're starting off with is the formation of the entity. And the first choice that you need to make is where you're going to form the entity. And so usually that's either going to be your home state or Delaware. Your home state will likely be cheaper, and that may work fine, in particular if your owners are local or are from neighboring states and are familiar with the jurisdiction. Delaware will likely be more expensive, but if you're seeking more sophisticated investors from other states, they may require Delaware because it is familiar to them and they have fewer concerns about what they may not know about another state's laws. Delaware has modern corporate and LLC statutes that are reviewed and improved annually by the Delaware legislature. And Delaware also has a well-developed case law, so there's more certainty in corporate decision-making. So once you've made your choice of jurisdiction, then you need to choose the type of entity you want to form. And that usually comes down to one of three options, either a C corporation, an S corporation, or an LLC. For C corporation, there are no restrictions on ownership, but the main issue is that a C corporation's profits are subject to double tax, once at the corporate level and again on dividends received by shareholders. So another choice might be an S corporation. S corporations have pass-through taxation, which means that corporate profits are taxed only once at the shareholder level, so there's no corporate level income tax. But the big issue is that S corporations have restrictions on the number and kinds of investors that they can have. S corporations can only have up to 100 shareholders at the maximum, and generally ownership is limited to individuals except in certain circumstances. So most entities are not eligible to own S corporation stock. In addition, S corporations are limited to a single class of stock when it comes to economic rights. So an S corporation can have voting and non-voting stock, but it cannot have common and preferred stock. So a third option might be an LLC. LLCs are extremely flexible. I like to think of them as creatures of contract. Most LLC laws allow the members to agree in their operating agreement to be governed how they like, with the exception of certain non-waivable provisions, which vary based on state law. A typical non-waivable provision might be a restriction on the ability to limit the fiduciary duties of managers and members. By default, LLCs are taxed as partnerships, which have pass-through taxation. But an LLC could also be elect to be taxed as a C corporation or an S corporation if that was advantageous. And unless S corporation taxation is selected, there are no limits on ownership of LLCs. But I'd further note that LLCs are not able to take advantage of certain provisions of the tax code that are limited to corporations, such as tax-free reorganizations and incentive stock options for employees. So when selecting your entity type, it's important to seek advice and input from your accountant and any potential investors. The recommendation you get may vary based on the current tax rates, the company's operations, and projected income and losses. So moving on to governance documents. For a corporation, the key documents are the articles of incorporation, which are filed with the Secretary of State. The key aspect is usually the description of the different classes of equity and their relative rights and preferences. These are usually described in the articles. The second document would be the bylaws, and these are usually pretty straightforward and provide details, for example, on how to call and hold director and shareholder meetings. And you may also have a shareholders agreement, which is a contract between the corporation and its shareholders. This document usually will include transfer restrictions on stock, such as a right of first refusal, and buy-sell rights, which provide an option or a requirement to purchase a shareholder's shares on events such as death, termination of employment, disability, or bankruptcy. It can also include voting or control provisions. For an LLC, the key documents are the Articles of Organization, which are filed with the Secretary of State and usually only contain basic name and address information. There's usually not a lot of detail there. And then the operating agreement, which is the contract among the members for the governance of the entity. The operating agreement is similar to a combination of the bylaws and a shareholders agreement for a corporation. And so that's really where the meat is. Typical terms would include management rights, tax allocations, distribution rights, transfer restrictions, buy-sell rights, and distribution provisions. And finally, on equity structure, generally companies can have common interest and preferred interest. Founders are typically issued common interest with equal voting and distribution rights and really no other special rights. Subsequent investors may require a different class of interest with preferred economic or voting rights. This could be like a preferred return in timing or amount, a liquidation preference, so they would be the first to get money on a liquidation of the company, and a right to elect members of the board. So next slide. Matthew and I also wanted to talk some about governance, and just starting at the start, the roles of officers, directors, and owners. So many entities choose to be governed by the corporate governance model, and in that there are three levels of management. The first level is the owners, and those are the shareholders for a corporation or the members for an LLC. The owners elect the directors for a corporation or managers for an LLC and approve other fundamental transactions such as mergers, sales of all assets, or dissolution. The second level of management is the managers for an LLC or directors for a corporation. Managers and directors are responsible for managing the business under the statute and under the governing documents, and for developing the strategy and policies of the company. The board can only act as a group. The board also appoints the executive officers of the company. So the third level of management is the officers, who are responsible for managing the day-to-day affairs of the company and executing the strategy, policy, and transactions approved by the board. Particularly in an LLC, this corporate governance model can be varied by contract in the operating agreement. So an LLC can elect to have a flat management structure and be member managed. If an LLC is member managed, it has no separate managers, and the members can also manage the day-to-day affairs of the company. So I wanted to talk a little bit about the importance of developing and keeping adequate corporate records. The entity's formation documents are on file at the Secretary of State, and their updates to these documents are typically pretty infrequent. The primary governance documents, such as the bylaws and shareholders for a corporation and the operating agreement for an LLC, should be reviewed periodically to ensure that the provisions are being followed and to determine whether updates are warranted based on changing circumstances. In many companies, these documents tend to be ignored until there's a disagreement among the owners or a shareholder departs, and then they become critical. So it really is important to make sure that those reflect the way the company is operating and the agreement amongst the owners for the operation of the company. The corporate minutes. Owners, managers, and directors should meet at the Times required by the Act and the company's governance document. That's just good governance for the company. And when you're in these meetings, you should evidence them with minutes. We typically recommend that less detail be included in the minutes to encourage open discussion by the parties and to discourage Monday morning quarterbacking after the fact. But there are times, such as approval of significant transactions, when detail is needed to ensure the approval is clear. And then finally, ownership records. For an LLC, this is usually easier. Most LLCs just contain a schedule to the operating agreement, which is amended from time to time as owners come and go. For a corporation, the shares are usually certificated, and you keep a ledger tracking the share ownership. But attention to these corporate records and proper record keeping is very important. If you have a privately held company with more than one owner, having a well-drafted operating agreement or shareholders agreement is essential. This will provide owners with certainty on how the departure of an owner will be handled and allow the owners to be able to control who they will be in business with. It's also important to keep your ownership records up to date, because if you sell the company, your records will need to prove that the company is owned by the people that you say own it. Cleanup of stock records is a frequent problem and can become difficult to fix as time passes and people move on. Managers and directors must abide by the rules set forth in the governance documents. Failure to follow these rules may end up in disputes between the owners or between management and the owners. And finally, corporations and LLCs are limited liability entities, meaning that the owners and managers should have no personal liability for company actions. But a plaintiff can try to pierce the veil and seek to hold owners personally liable for company actions. A key element of a piercing claim is failure to follow corporate formalities. Thus, if an entity does not follow corporate formalities, then the plaintiff will argue that the law should not recognize the corporate liability shield.
And one thing I would add to that is, for our work with companies in the life sciences industry and beyond, we've seen startup companies run into trouble when they haven't followed some of these rules. They don't have an up-to-date operating agreement. They don't have up-to-date ownership records. They're not keeping good corporate minutes, and that creates the opportunity for trouble to come down the road. And one of those things we're going to talk about next is in the governance world is the business judgment rule. So before we get into the business judgment rule, let's say you're a director of a company, of a life sciences company. Well, what does that mean? Well, it's hopefully it's rewarding for you professionally and financially, but there are some duties under almost every state's law. You're going to have a fiduciary duty to the company. You're going to have a duty of care, a duty of loyalty, a duty of confidentiality. The business judgment rule is a way under state law that your decisions can be protected. And so the Monday morning quarterback example that Jones gave earlier, if you make a decision as a board and it's not good for the company, shareholders could then bring a shareholder lawsuit saying, you made a bad decision, it cost me money, and now I want you to pay for it, board. And so the business judgment rule protects the board from that. And what it says is, if a board is informed and acts reasonably within the scope of its authority to make a decision, then that decision is not going to be second guessed by the courts, even if it's wrong. So it's a powerful tool. And if you sit on boards, you need to be aware of it. The key to getting the benefit of it, though, is to have a good process and to have documentation of what boards used in terms of information to make decisions. So if you have no minutes and you didn't ask any questions and didn't talk to anybody and you made a big decision and it went bad for the company, there could always be questions about, well, did the board act reasonably? So this is a good thing, the business judgment rule. You need to get the benefit of it, but to get the benefit of it, you need to follow this corporate formality processes that Jones talked about in the previous slides. So keep that in mind when you're a board member. You have a fiduciary duty to the company. That leads us to the next issue we want to talk about, which we've seen happen a lot in life sciences companies and other companies, and that's conflicts of interest. So a conflict of interest is when a person is in a position of influence, whether it be an officer or a board member, and they are making a decision related to the company, but they have a relationship with someone that is dealing with the company that they've not disclosed, that causes that decision that they're making about the company to be called into question. So the classic example is if I'm on the board of a company and we're deciding to buy a piece of property and the property is owned by my spouse or somebody in my family, that's a very garden variety, black and white conflict of interest. I should disclose the relationship. I should recuse myself from making taking any action regarding the vote. The independent board members or management team would make the decision to go forward with that transaction without me involved. This actually trips up more people than you think. And so what we advise our companies, our clients to do is to have a process where board members and even officers are disclosing financial relationships primarily that could affect the ongoing business of the company. And that's done on an annual basis. I've had clients come to us and say, well, it would be so much easier if you could just define a conflict of interest and we would have that as a policy. We can't really do that because we don't know what every financial relationship will be. And so you just describe a process where financial relationships are disclosed. The board members are trained that when a situation comes up and they've not disclosed a financial interest or they've not updated it, then they can tell the board before they go through with a decision. Failure to tell a board and participating in a decision that creates a conflict of interest could put the individual board member at risk for being removed from the board or having personal liability. So this is a big deal and something to pay attention to. So a couple of issues on corporate formality that we run into all the time. And just to give, that's recusal with conflicts of interest. The way it should go is if a person has said, like in my example with the purchase of the real estate, if I said, I have a conflict, I have this relationship, do you think it's a conflict, board? They would say yes. There shouldn't be a lot of discussion with me in the room about the deal. I should get up and leave. So when you are dealing with board members who have recused themselves, this gets a little bit uncomfortable, but you should ask them to walk out of the room while you're discussing it. That just makes it a little easier, and that's a much cleaner process. Well, let's jump to indemnification policies. So if you're a board member or a member of management and your company gets sued by a third party, and then you get sued in your capacity as an officer or a director, what happens? So there's state law protections in some instances for this, but there really should be some policies at the corporate level that address this issue. And most companies say if our CEO or if our board chair gets named in a lawsuit that the company gets named in, we're going to indemnify them, which means they're going to pay for their lawyers to defend them. And if there's any damage associated with that, they'll pay for that too. But the indemnification policy needs to have limits. So the indemnification policy needs to say that board member or officer needs to be acting within the scope of his or her authority. And they can't be a bad actor. They can't be the reason that the company got sued. If they did, you might not indemnify them. This gets to be a very tricky situation, particularly in government investigations, where the government comes in on a compliance issue and they're doing this more and more. They go after an individual as well as the company, and the company's put in a tough position as to whether to indemnify the existing executive or board member. But the best way to address that is to have policies up front. All right, moving along to other governance issues that we've dealt with our life sciences company, managing supply chain. So we're still in the COVID-19 pandemic, and one thing we've learned during this process is the supply chain is critically important, particularly in life sciences. And I think the life sciences companies that we work with did an admirable job in managing their supply chain, which could cripple the company if it didn't. Part of the challenge was, did you have a backup plan? Did you have a plan to maintain regulatory compliance? So in the healthcare field, when people were trying to get their hands on PPE from all sources, we were advising clients on, well, can you import this from China or Vietnam, and does it meet FDA standards? All of those are supply chain issues. No one could have really predicted that, but what you can do is do some stress testing on your supply chain, making sure you verified who your vendors are and what their emergency plans are. Their ability to produce the good that you need is affected. In a future webinar that we'll be doing, we're going to be talking about some repatriation efforts that will be happening in the state to create more domestic supply chain. And that's going on all over the country, where different states are trying to make sure that in the life sciences world in particular, they do have some additional supply chain opportunities. I do want to send a shout out to SC Bio and NC Bio, who I think were very helpful to life sciences companies during the pandemic to help them manage their supply chain challenges. Managing technology is also critically important. A lot of life sciences companies, that their business is technology, but we've seen some of our companies have issues because they didn't pay enough attention, frankly, to some of the billing software or the other software they have. And then when it went bad, it put a huge burden on the company. So invest in some time and some expertise into making sure in-house you know how to manage your technology, whether you have a chief technology officer or a chief information officer, but make sure you understand what your software contracts say about your rights should there be failure or, and we'll talk about it in a minute, a breach with cybersecurity. Let's jump on cybersecurity because this is a big issue and we're going to have a separate webinar just on cybersecurity. I read an article yesterday that said 98% of cybersecurity breaches are caused by human error, and the average breach cost the company almost $4 million. That's a big number. So whether you're a startup entity with 3 employees or whether you're an entity that's got 5,000 employees, you need to be thinking about cybersecurity and privacy issues. The European Union has their version of HIPAA. They recently had a case that came out that said transferring data to the U.S. is not as safe as transferring it in the European Union. So they're now putting some technical limitations on that. And so U.S. is responding to that. U.S. companies are responding to that. But be aware as you're transferring data, whether it be protected health information or other information, you're going to be held responsible in many cases if it gets lost or it gets open to the public. So for a lot of these life sciences companies, cybersecurity should be a primary source of what you're thinking about in terms of your compliance efforts and your risk mitigation efforts. Immigration. Immigration continues to be a growing area for life sciences. We have a whole immigration team here that advises folks on bringing people in from different countries, and it's become important that to be competitive on a global level, you have this international talent. The life sciences companies have a lot of opportunities in the visa world. We're going to have a separate webinar just on immigration, but depending upon your needs and whether or not you are working with folks who are training here and doing your academic work in the state, and then looking at opportunities to become employees for you after that, immigration is something you need to be focusing on as a part of your strategic plan. Okay, other key areas of governance that we're going to hit, developing and protecting intellectual property. So intellectual property next to your workforce might be, for life sciences companies, your most valuable asset. And you need to take steps to protect it. And that's both formally through trademark or patents or copyrights, whatever it may be, or through efforts to keep information confidential and contained within the company. If you're creating something that's of value and you have employees doing it, you need to have work for hire agreements with your employees. So if they create something on your time while you're paying them, it belongs to you, and there doesn't become a fight over who the intellectual property belongs to. And that is much better addressed in the front, at the beginning of a relationship, as opposed to after you've discovered the latest, greatest technology trend that's going to make people billions of dollars. So make sure you have a process and a strategy focused on intellectual property protection. We're going to have a separate webinar just on intellectual property within life sciences, because that's way beyond my scope. The next thing we want to talk about is trade secrets. Now, everybody has trade secrets, no matter if you don't have a scientific aspect to your company, everybody has them. To start with, it's your client list, who you do business with. That's very important. And you need to take internal steps to protect that, because humans being humans, you could have employees who get disgruntled or decide they want to move and they want to take something they know. This happens more than you would imagine. And what we've seen is that this has been happening more during the pandemic as people have been working from home in a virtual environment, I think it just might be easier for them to just take this corporate asset, take this trade secret. And trade secrets are defined as something of value that someone else would value that belongs to you, that is critical to your business. And different states define it different ways. That's the way I've just sort of made a general definition. But companies have to spend millions of dollars litigating to protect trade secrets. And before you get down that road, you want to make sure internally you have some idea, what are we protecting? What is trade secrets? What policies and procedures have to be put in place to protect them? Because that's going to be looked at if you get into litigation. Likewise, when you're hiring new people and they're bringing their expertise, please make sure they're not bringing trade secrets from someone else, because that's the best way to buy a lawsuit. So when you hire somebody, you don't anticipate getting sued because of it. So you're going to check whether they have the ability to work with you through covenants not to compete and things like that. But you need to make sure you don't accept anything that's a trade secret from someone else. We're going to have a separate webinar just on trade secrets, because this is a very hot growing topic in the life sciences industry. Okay, another important governance issue if you're thinking about running a life sciences company is developing and protecting your company's brand and reputation. This is crucial. In today's social media world, your brand and reputation is everything. And it is very easy for that to be tarnished through a disgruntled client, employer, whoever. Somebody just had a bad experience with you. So having the strategic plan to manage that and having the expertise and guidance to manage that is very important. This is so important that we created a subsidiary, MP Strategy, because we were seeing several years ago, going back, I think 5 years, that these kinds of issues, brand and reputation, were so important to our clients, and they were working together with our legal issues, whether it be acquisition of a company and conveying that news to the world, or defending a lawsuit. They were all dealing with reputational public relations issues. So we created this subsidiary, NP Strategy, that advises clients, and now they've been a massive success, and they do that on their own for their own clients as well as firm clients. But this is something you need to, in the social media world, you need to have someone thinking about every day, not just here and there, every day. It's very important. And finally, this is something I know you're focused on, is managing your executives and key employees. When you're hiring folks, they need to have a contract if they're at a certain level. And in that contract, you've got to decide, is that person important enough to merit a covenant not to compete, a covenant not to solicit, something that protects you should there be a parting of the ways. And in most states, covenants not to compete are enforceable and legal as long as they are reasonable in terms of scope and geographic time and geographic duration. This is something that's very important. And then this is something where you can word into your employment agreement protection on trade secrets, protection on them not disparaging the company if there's a separation. These are key things to keep in mind, because you don't want to lose key employees, but if you do, you want to make sure that the damage to the organization is minimal. Okay, and this is probably the biggest area that I want to emphasize today for the stuff that I'm talking about, and that's the role of boards in life sciences companies with compliance. And by compliance, I mean compliance with primarily the federal, but also state, legal and regulatory issues that affect the company. A lot of you do business with the federal government, and when you do business with the federal government, it can be a great thing or it can be a terrible thing. If you are primarily selling a product or service to the federal government, you need to be very aware that there are things you can do that could be innocent mistakes that could lead to significant potential liability, whether it's how you build them and whether they think the claim is valid or not. The Federal False Claims Act was created after the Civil War because the federal government was afraid it was getting overbilled by military contractors. So in the last 25 years, the healthcare life sciences industry is where the Federal False Claims Act has been most active, and it's really resulted in billions of dollars of penalties paid over the last 20 years. And so it's something you need to focus on. So the board is ultimately responsible for the company's compliance. That's part of your fiduciary duty. So if you sit on a board or you're an officer, you need to be prepared to say to the board when they ask, what is our compliance plan? here it is, and it needs to be updated, and it needs to be an evolving document. If you're a certain size company, you should have a compliance officer whose job it is to deal with the federal, state regulatory compliance. And you're doing audits, you're looking at yourself to figure out how you're doing with respect to ongoing compliance. But this is a very big issue. You want to look at whether you've got adequate training. The board should be trained, the officers should be trained on various compliance issues, because it does help when you have an active compliance plan for the company and there is an issue or investigation. One of the first things that the government will look at is, let me see your compliance plan and how active are you? And let me talk to your compliance officer. If they are satisfied, the government, that you've got an active, robust compliance plan, it often minimizes the potential for them to be very aggressive with you, because they understand things happen. People make decisions and they don't tell their supervisors, and there's a mistake. But if you've got a good compliance plan, that will give you some benefit of the doubt. Another benefit of the compliance plan is you can go to the government if you identify an issue. And most of these issues are billing, because it's very complicated depending on what your business is, how you bill the government, and some of your other financial relationships. Another key point here is insurance. As a board member, you need to make sure that the entity is adequately insured. Not necessarily overinsured, but you need to make sure you have adequate liability protection for the work that you're doing. If you're doing work that could require antitrust coverage, is that something you want? Is that something that's feasible? Do you have compliance insurance? There is insurance out there now that companies can get, that if there is a federal false claims or an anti-kickback claim or some other type of federal regulatory investigation, it'll at least pay the cost to defend the litigation. It won't pay any damages. But for smaller and medium-sized companies, the cost to defend can be a huge burden on the company. So we want to make sure that you've done that insurance analysis. D&O insurance is very important, particularly if you have outside directors. They're going to ask for that, directors and officers insurance. They want to make sure they're not going to rely solely on the business judgment rule to protect them. They're going to make sure that there is some insurance policy that if the board gets sued, they'll have adequate legal representation to defend that. And so D&O insurance, whether you're on the board of a small nonprofit or it's a large for-profit, that's something that almost everybody should have. Okay, now we're going to pivot to the capitalization and equity and debt. Jones will pick that up.
Yeah, absolutely. So in capitalizing the company, really two ways: borrowing money and taking on an equity investment. So first off, I want to talk about lenders. This is the source of first resort for an operating company. If the owners can fund the company through debt on reasonable terms, this allows the shareholders to retain more equity, which should be their most valuable asset. Keep as much equity in the company as you can. But the company may not be creditworthy or may have difficulty servicing its debt, or lenders' terms may be unreasonable. So if reasonable credit is not available, a company may desire to raise capital through equity. So sources of equity funding would include, first off, friends and family. It's common in the early stages of a company to seek funding from friends and family. Friends and family are usually not too demanding on terms and will typically invest alongside the founders without requiring special rights or preferences. For most people, however, friends and family are a limited source of capital, so you may need to move up to an angel investor. These usually are more sophisticated professional investors who invest on a serial basis. On the low end, they may look a lot like friends and family, with just maybe a couple complications. And on the higher end, they will require more complex investment terms, such as preferred stock, board participation, control or veto rights, and exit rights from the company. Above angel investors, you'd have venture capital and private equity investors. Venture capital and private equity investors are very sophisticated and will propose their own investment terms for negotiation. Generally, venture capital investors invest in minority positions in early stage companies, and private equity firms tend to invest in later stage companies and take majority stakes. That's not always a hard and fast rule. They start to look a lot alike. The terms they seek can be very similar to the ones you might find from a sophisticated angel investor, but there's going to be a larger investment amount, and the deal terms will be even more complex. The key thing I want to point out here, though, is when you're selling securities, when you're issuing equity or certain types of debt, you're selling securities. The offer and sale of securities is regulated at the state and federal level. Equity is almost always a security, except for certain LLCs that are managed like partnerships with a limited number of owners, and all the members are actively participating in the management. One thing that people don't realize is that promissory notes are securities too, so it's not just the equity securities of the company. Certain promissory notes are not, such as short-term notes, less than 90 days, maturity, and secured commercial loans. But if you were to go out and sell promissory notes to a group of investors, then that's going to be considered a security as well. The securities laws consist of two parts, the registration requirements and the anti-fraud rules. Under the registration requirements, all offers and sales of securities must either be registered or exempt from registration. So for a small offering to a limited number of investors, likely going to be an exemption available. Otherwise, you're moving into land public offerings, which is an enormous undertaking. Under the anti-fraud rules, the issuer must make full and fair disclosure of all facts that would be material to an investor in making an investment decision. So that's pretty critical, and that's difficult to do. So you usually discharge that by putting together a confidential offering memorandum to disclose the risk related to the company. If there's no exemption available or the anti-fraud rules are violated, then the investor has a rescission right, meaning that they can ask for their money back plus interest plus attorney's fees. And the key here that people don't recognize is that the executive officers, directors, and controlling persons of an issuer may be jointly and severally liable along with the company. So in these cases, a lot of times what happens is you do the offering, everybody's happy. Maybe there's a turn of events for the company, and you've already spent the investment. So when someone comes and makes a securities claim, the officers, directors, and controlling persons may be the ones who are standing behind that and might be required to satisfy that claim. So before you engage in a securities offering, it's really important to talk to your counsel to come up with a compliance plan. So.
Okay. All right, we're running up on time, so I'm going to go through reimbursement very quickly. So obviously, as a chair, as a board member and officer, you need to understand where is the revenue coming in for the company? How are we getting paid? And to start off, let me start with the service and sales agreement. So if you're selling to private individuals or companies, you need to have service agreements that are template agreements, not customized agreements for everybody. A template agreement, and it needs to have proper protection for you, and it needs to have choice of law provisions in your state, not in some other state, and it's the choice, the venue needs to be in your state. These are basic concepts you need to make sure in your service or sales agreement, whatever you have. You need to make sure, is it your relationship exclusive with this particular customer, or can they go to other people? That's something you've got to negotiate. If it's exclusive, you need to put it in the agreement. You also need to look at your contracts with the sales force. If you are selling directly or indirectly to the federal government, how you pay your sales force could be a relevant issue. The government, the federal anti-kickback statute says that you cannot pay remuneration to a person in return for referrals of services that are paid for by the government. And there are safe harbors and exceptions to that, but you need to give a fair amount of focus on that. So reimbursement and compliance go together. If you have agreements with health plans, you need to make sure that you understand the rules associated with the health plans so you can get paid. Now, one of the things that happens with life sciences companies, particularly ones that are developing new technology, new services, are how do you get people to pay for it? And so if it's in the healthcare space, how do you get private payers to pay for it? How do you get a governmental payer to pay for it? You need to plan for a fairly long time period for that to happen. That does not happen overnight. As we know, if it's not required to go through FDA approval, the payers still have a fairly skeptical view of new technology and new paying for new services. Give you an example. Telehealth exploded during COVID, but there was no breakthrough in technology in 2020, nothing like that. What happened was, because of the pandemic, the payer said, we'll pay for it. And the minute they said they pay for it, we saw an explosion of growth. I don't think that's going to go back, but that reimbursement drove this. So reimbursement, you need to have a reimbursement strategy based on your business, and it needs to be linked to compliance.
Another topic we wanted to cover was strategic growth, and I really discussed briefly 3 ways to do that. And one is buying other companies. 2 ways to approach this would be like a horizontal acquisition, where you're buying a competitor either locally or in another market to increase your customer base, and then a vertical acquisition, where you're usually buying someone in your supply chain, either frontwards or backwards. So just 2 different ways to approach this to accomplish 2 different goals. Horizontal acquisition is really to increase your market share, whereas vertical acquisition would be to reduce the cost of production, ensure tighter quality control, or to control the manufacturing process. Another opportunity might be a joint venture. This joint venture is a collaboration between 2 independent companies. It's usually for a single-purpose project or new technology, or to operate a business that's separate and apart from the primary businesses of the joint ventures. In doing that, you need to negotiate the key terms. Key terms would be, what are the ownership percentages of the JV partners, the amount and kind of contributions required of each party to the JV, economic rights of the parties, restrictions on the parties such as non-competes, and exit strategies for the joint venture parties.
And when we're talking about buying other companies or affiliations or joint ventures, we want to make sure, if you're doing business with a competitor and you both have significant market share in whatever you're selling, you need to think about antitrust, because there's going to be more antitrust enforcement under the new administration than there was in the prior, although there was a fairly significant amount of antitrust enforcement under the Trump administration. We think that will increase. So when you look at affiliations, and affiliations are essentially contractual arrangements with another party where you might be a competitor, you might not, you might be a supplier, but you're going to pursue some collaborative effort together. And it is completely, usually a creature of contract. Now, a lot of times affiliations they start out, we'll work on this new venture together. We won't do a joint venture where there's actual equity, and it will evolve into a joint venture or an acquisition. But affiliations are a good way to try to do some strategic collaborations, and it's a test case. Will it work? Will the cultures work? Will the business concept work? And you've seen affiliations in the healthcare world, and life sciences world. You've seen a ton of them, and they tend to lead to more integrated. But remember, when you're affiliated, there are certain things you can't do in terms of if you're competitors under the antitrust laws. So you need to get some antitrust evaluation on that.
Okay, selling the company. So going over this briefly, where you usually start is, are you going to deal with a strategic buyer or a financial buyer? Sometimes you have a choice, sometimes you don't. Strategic buyer, they have different characteristics. Strategic buyers are usually competitors or somebody in your industry. They like to focus on synergies and integration of your company into their company. They're usually buying for the short term, so they don't always require short-term profits. They just want to see how they're going to bring value to the buyer's shareholders. And they also aren't really concerned about back-end infrastructure like accounting and finance and human resources. They usually already have this. One thing that's really nice for selling companies, they're less sensitive to industry risk because they already know and understand it. And they may pay a premium for the right strategic fit. So they may pay a higher multiple than a financial buyer. So a financial buyer is going to be, for example, a private equity firm or a family office or a high net worth individual. Financial buyers are in the business of making investments in company and realizing a return in the near term. So they're focusing on cash generating capability and growth. Their investment horizon is usually around 5 to 7 years. A complete company with back-end infrastructure is very important. They're looking for the company to be able to stand alone. They're certainly much more sensitive to industry risk because they're just not going to be as familiar with it. And generally speaking, they're looking to buy low and sell high, and there's no synergistic fit with a financial buyer. So to begin finding a buyer, you need to market the company, and it can be difficult to sell your company. You may not know who the potential buyers are. Many business owners don't have a good feel for what the value is of what they've built. So you may want to hire a business broker or an investment banker to help with the sale, and they do lots of things that are really helpful. They can help you assess the value. They can help you put together a pitch book to market the company. They can help you identify potential buyers. They can run an auction process to generate interest and solicit bids. They can manage communications with potential purchasers, which is difficult and awkward for the company. And they can help you evaluate the various bids that might come in. And for key issues in a transaction, it begins with the due diligence. Once you've found a buyer, then it begins with the due diligence. This is an enormous amount of work for the seller. The seller's having to do two jobs, running the company and satisfying these really burdensome information requests. And at the same time, you'll need to be determining the transaction structure. Most smaller purchases will be an asset sale. Buyers like this because they can write up the value of the assets on the sale, and they can pick and choose the liabilities they assume. For larger transactions, it's usually going to be a stock purchase or a merger. And that's because if a company has a lot of assets, employees, and contracts, it's just difficult to effectuate the transfer of all those items. And a lot of times the selection of the transaction structure is tax driven, so we'll need the accountants involved. You'll need to agree on the purchase price, but purchase price has its own issues. Will it be paid in all at closing, or will there be seller financing, which can be risky for the seller? The buyer might also require contingent consideration, such as an earnout. So you may not know whether you get paid part of the consideration unless the target performs after closing. And you may have to escrow a portion of the purchase price to satisfy liabilities from the purchase agreement and from the company prior to closing. Key terms in the purchase agreement include the representations and warranties of the target, which are promises about the condition of the company, the disclosure schedules that you'll have to prepare for the purchase agreement, and the indemnity, which is your trailing liability after the sale, which you'll try to limit by contract. And finally, a big task that you need to take care of is obtaining third-party consents, and that can be difficult. You have to deal with your lenders, your landlords, get regulatory approvals, and find and get consents from key contracts, and that can be really tricky because a lot of times your customers don't necessarily want to deal with someone other than you.
One thing I'd make a point about is in this health and life sciences world is the private equity investors. There's a ton of money out there with private equity trying to invest into smaller, medium-sized companies. That changes the company, and it's very good for many companies, but you need to go into that with eyes wide open and understand what you're getting, because you're going to have an impact on the company, its direction, its leadership, and you need to make sure you weigh the benefit of that additional capital versus directional and strategic control of the company. So I think that wraps it up. We went a little long, but if there are any questions, you can use the chat feature, or you can just follow up with us afterwards. I do want to make you aware that in April, we're having the next webinar, the next Nexsen Pruet Life Sciences webinar on April 28th, dealing with the onshoring of life sciences industry. And that's what we've talked about, and the head of our economic development team, Tushar Chikli, will be leading that, and we might have some additional panelists. I don't know. I know he's talking to some folks. And then in May, we're talking about offensive and defensive strategies for protecting your company's trade secrets with Nicole Margot and Jenny Claverius, who have a lot of experience in litigating trade secrets, and you get the benefit of their experience. And then in June, we're going to talk about the importance, more detailed importance of discussion on the importance of compliance plans. And then subsequent months, we're going to have webinars on immigration, cybersecurity, the importance of valuations in fair market valuations in the life sciences industry. And we're also going to be talking about how to manage the regulatory world of whatever state you're in. So if there are other ideas you have, please send them to us, and we'll be glad to follow up. But if you have any questions, please let us know. Otherwise, we appreciate you joining us this morning.